Comey was spying on Trump. Well, the reason he was writing the memos was to create a record so that he could destroy
No
him.
American knowingly colluded with the Russians to interfere in our election campaigns. Oh, wait, unless you mean Hillary Clinton. Pardons, prosecutions, and transparency.
Hey everyone, Judicial Watch President Tom Fitton here with our weekly update here on social media. Thanks for joining us this week. An historic week for Judicial Watch, accountability and the rule of law. We've been granted the ability by a federal court to question Hillary Clinton under oath on her emails. So I'll give you all the details about that historic litigation and the major achievement frankly, by our lawyers and the entire team at Judicial Watch. So a lot to talk about on that alone. Plus we have Chuck Schumer, who is the leader of the Democrats in the Senate, threatened two Supreme Court justices. Threatened them. I'll talk about that. Plus we have a new hearing, scheduled for Monday on an outrageous law in California that requires a quota for women on the boards of directors of corporations. Completely unconstitutional. So I'll talk about that. You know, the attack on the rule of law is so broad in this country, isn't it? By the left and their minions. It's just incredible. But first up is the great news that Judicial Watch is going to be able to question in person Mrs. Hillary Clinton under oath about her emails and Benghazi attack documents. The underlying lawsuit was filed in 2014. It was a Freedom of Information Act lawsuit, and it's the lawsuit that led to the uncovering of the Clinton email scandal. Judicial Watch back in 2014, you may recall, had uncovered the infamous talking points created by Ben Rhodes at the White House that were the basis for the big lies by Susan Rice, State Department, Hillary Clinton, Obama, all of them, who said that the Benghazi attack was the result of a spontaneous demonstration in reaction to an internet video, when in fact they all knew that was not the case. It was a planned terrorist attack, and a terrorist attack that they had, at least if not the specific nature of the attack, plenty of warning that something bad was going to happen at the Benghazi Special Mission Compound that had been set up by the Obama administration after they allowed the murder of Muammar Gaddafi. Now, we did notice in that major find, which also, by the way, changed history in the sense it led to the creation of the Select Committee on Benghazi by John Boehner, gave us, Trey Gowdy's committee. But we noticed even then, where are the Hillary Clinton emails? So we asked again, more specifically, to figure out where Hillary Clinton's emails were, specifically on the Benghazi talking points. And we're getting the runaround, and eventually they told us, the end of 2014, told the court at the beginning of 2015, that they had given us all the documents there were to give us, other than these other documents they really want to tell us about directly. And then sure enough, a few weeks later, it's reported in the media, specifically the New York Times, that Hillary Clinton had all these secret emails that she was using to conduct government business. The email server was exposed. And there's no doubt that our pressure, our FOIA litigation pressure, and that was been confirmed, was the result of, resulted in the disclosure of these emails. And of course, the rest is history. In many ways, she's no longer president because of that cover-up, or she was able to become president because of that cover-up. But nevertheless, Judicial Watch continued to try to uncover and press for more information about this dramatic attack on our transparency law, this outrageous obstruction, cover-up, you name it. And another one of our cases was reopened as a result of that litigation, as a result of that find. And we were able to question some of the Clinton witnesses under oath about the emails, but we weren't able to question Mrs. Clinton under oath. She signed or she gave us written answers under oath to questions the court let us give to her, But as you might imagine, her answers weren't all that helpful in trying to figure out what really went on. So another court, the court in this original case that uncovered the Clinton email scandal, as I said, Judge Royce Lamberth, late last, well, not last year, but I guess it was late in January, 2018, granted us discovery, additional discovery, into the Clinton email issue. And I think we've deposed so far 19 witnesses. And that discovery has just been gangbusters in terms of its disclosures about the Obama White House was behind the big lies when they were telling people, asking for Clinton emails, oh, there were no records. Hillary Clinton was warned 6 times, she and her top staff, about security issues using private emails that the State Department officials and seemingly the Justice Department knew full well about Hillary Clinton's emails but didn't want to tell anyone about it. And just more recently, we forced out of the Justice Department and the State Department a document showing that there was an email about specifically Benghazi talking points that they had been hiding from us and the American people for years. And of course, if they disclosed it in a timely way, the jig would have been up on the Clinton email scandal many, many years ago. And even worse, the FBI is continuing to, quote, find Clinton emails. And they give them to the State Department reviews them and gives them to us. So we think there's plenty of reason to ask Mrs. Clinton for her testimony directly. And we were in court last December, just a few months ago, and I've told you this before. I get to go to court and I represent Judicial Watch in the corporate capacity. So I'm the client as president of Judicial Watch. So I have to sit there, I got my suit and tie on, I have to remain calm, you know, don't do anything to mess up the case, try not to draw attention to myself. But I tell you, it's hard because I'm in there and I'm with our lawyers. You know, we usually have 1 or 2 lawyers. I think in that specific ruling, that specific hearing, we had, I think, 2 attorneys. Our lead attorney on the case was Ramona Kotka, who you may have seen here on our social media as well. And across the way, on the other side, were 6 government lawyers from the Justice Department and State Department. Plus, Mrs. Clinton had 2 lawyers. Her top aide, Cheryl Mills, had 2 lawyers. So it's just little old Judicial Watch versus a whole group of attorneys paid for with your tax dollars. Justice Department and State Department of this administration defending Hillary Clinton in court. And in fact, trying to stop us from getting to question her or get any additional questions answered. And the court said no. In fact, the court said their arguments are preposterous. You may have seen news that we did get the Clinton email, we did get her testimony this week, but I doubt you saw news that a federal court judge criticized the Justice Department and the State Department for their cover-up of the Clinton email scandal. And if you want to know why President Trump is frustrated, he sees this. In fact, when I've complained about this on Lou Dobbs' show, he tweeted, and Dobbs highlighted the fact that we were facing opposition from the Justice Department and State Department. I think the president's tweet on that said it was disgraceful. But thankfully, the court wasn't cowed by the Justice Department in this circumstance, and he ruled in our favor. So within 75 days, Hillary Clinton, Cheryl Mills, 2 other witnesses have to come and have to come to judicial, or I don't know where we're going to hold the deposition, but they're going to have to testify under oath in person to Judicial Watch attorneys. So that 75 days, the ruling came out earlier this week. It's May 16th. It has to be done by May 16th. And we get to subpoena Google for potential cache of Clinton emails. I'll tell you about that later as well. Now, we didn't get everything we wanted. The types of questions we can ask Mrs. Clinton It's not everything you might want to ask. It's not everything I might want to ask. But certainly this deposition testimony will be the most important questioning of Hillary Clinton on this matter ever. Because we know the FBI was running a pro forma compromise investigation. They had zero interest in prosecuting her, and they were just checking the boxes, granting immunity to everybody. In fact, we just uncovered, as I told you a few weeks ago, that Hillary Clinton, at the end of her FBI interview, said that she apologized to the FBI for having to investigate this issue, said she used the system for her convenience, but it turned out to be anything but for her convenience. So you've got this apology, admission / confession. You know what? But Peter Strzok said in his emails that they didn't put that into her FBI 302 report, which is the official narrative report of the interview. So we don't even know what the FBI asked Hillary Clinton or the full scope of her interview with the FBI. Because the FBI has this, in my view, corrupt process in documenting interviews of witnesses and targets. They don't record the interviews. And what happens is the agents go back and write up a 302 based on their notes and memory. And supposedly it's done contemporaneously. We found in the Flynn case it wasn't. But I'm just saying all this to highlight, well, you can't trust what the FBI did with Mrs. Clinton. And of course, she testified under oath. I don't know if she did it under oath before Congress. It doesn't really matter, since you can't lie to Congress, whether you're under oath or not. But either way, they had a ridiculous hearing, and Mrs. Clinton and her defenders say it was for 11 hours. You know, if you watch that hearing, you could go on for 24 hours, or you could go on forever and still not get information. Any witness can just power through those hearings without having to answer questions directly or substantively. That's just the nature of congressional hearings. They're just awful ways to get information. So this is going to be very significant in terms of the public's right to know, because we're going to be able to get information that the FBI didn't want to get, Congress was unable to get and kind of didn't want to get, but you can trust Judicial Watch to ask the most direct questions. And kudos to Judge Royce Lamberth, who is tired of the corruption he saw, certainly with the Justice Department and the FBI. But what a great victory for Judicial Watch, because our attorneys and lawyers, we uncovered the Clinton email case. We exposed so much, virtually everything we know about it is because of our work. And we began asking questions about Hillary Clinton and the State Department from before she became Secretary of State in 2009. So this is the culmination of not only that work during the Obama administration, but we have been focused on Clinton corruption since the inception of the organization. On other issues, people say, oh, you're obsessed with the Clintons. No, we don't like government corruption. That's the nature of our mission. And the Clintons were terribly corrupt when they were in the White House, and Mrs. Clinton was involved in a major corruption scandal as Secretary of State, not only with the emails, but the pay-to-play that was never adequately investigated. I make no apologies for wanting a justice and accountability over the major public corruption scandals that Hillary Clinton's been involved in. No apologies. There's a big documentary on Hillary Clinton out this weekend. They didn't ask Judicial Watch what we thought about what information we had about her conduct. I've read virtually every email Hillary Clinton sent and received. You would think the fact that she's in court with us, they would want to talk to us about it. Of course, that's just propaganda, it looks like. So we're telling the truth that the media doesn't want you to know. We're doing a heavy lifting that no one else is willing to do on this issue. And Hillary Clinton is still obviously a public figure. But more importantly here, and I'm going to read his ruling, it's not just Judicial Watch that wants answers and accountability, but a federal court judge. And Judge Lamberth, in his ruling, which is 11 pages, and I'm going to read it to you. I won't read every jot and tittle here, but I'm going to read you the ruling, because the media is not going to tell you the detail, and so you can trust Judicial Watch to give you the full scope of what you can expect from Hillary Clinton's deposition. And this is the memorandum in order issued. It was issued on March 2nd, 2020. It's Judicial Watch, Plaintiff versus U.S. Department of State. This is what the order looks like. It's available on our internet site, so you can read along if you'd like. But on December 6, 2018, the court ordered discovery into three main areas. A, whether Secretary Clinton's use of a private email while Secretary of State was an intentional attempt to evade FOIA. And B, whether the State Department's attempts to settle this case in late 2014 and early 2015 amounted to bad faith. And C, whether State has adequately searched for records responsive to Judicial Watch's request. So obviously, whether Hillary Clinton evaded FOIA, that's a big question. The bad faith in terms of attempts to settle the case, they wanted to shut the case down before they told us about the Clinton emails. And C is, where are all the emails? Although discovery in FOIA cases is rare, the court again reminds the government that it was State's mishandling of this case, which was either the result of bureaucratic incompetence or motivated by bad faith, that opened discovery in the first place. Discovery up until this point has brought to light a noteworthy amount of relevant information, but Judicial Watch requests an additional round of discovery, and understandably so. With each passing round of discovery, the court is left with more questions than answers. What's more, during the December 19, 2019 status conference, which was the court hearing I was telling you about, Judicial Watch disclosed that the FBI recently produced approximately 30 previously undisclosed Clinton emails. State failed to fully explain the emails' origins when the court directly questioned where they came from, and he drops a footnote. On February 12, 2020, Judicial Watch informed the court that a recently obtained Clinton email produced in an unrelated FOIA case involving State strongly suggested Secretary Clinton and her Deputy Chief of Staff, Huma Abedin, conducted State Department visits via text messaging as well. The government has not provided any information about whether such text messages were searched pursuant to FOIA. Going back to the text, furthermore, State has not represented to the court that the private emails of State's former employees who corresponded with Secretary Clinton have been searched for additional Clinton emails. State has thus failed to persuade the court that all of Secretary Clinton's recoverable emails have been located. This is unacceptable. State asked the court to close discovery, and to move this case towards dispositive motions and an eventual resolution. But there is still more to learn. Even though many important questions remain unanswered, the Justice Department inexplicably still takes the position that the court should close discovery and rule on dispositive motions. The court is especially troubled by this. To argue that the court now has enough information to determine whether State conducted an adequate search is preposterous, especially when considering State's deficient representations regarding the existence of additional Clinton emails. Instead, the court will authorize a new round of discovery as follows. We got a train going by. I'll let the train go by. And then the next section is titled Brett Gittleson and Yvette Jacks. Mr. Gittleson was director of the Office of the Secretary, the Executive Secretary's Information Resource Management, in 2013 and 2014. The office was charged with providing technical support, including email management, to the Office of Secretary during Secretary Clinton's years at the helm. In late 2012 or early 2013, Mr. Gittleson became the director
And in April or May of 2013, he discussed Secretary Clinton's email use with Gene Smolansky, an attorney in the Office of Legal Advisor. Mr. Smolansky had experience working on FOIA lawsuits, including one related to Mrs. Secretary Clinton's emails. Ms. Jacks was the deputy director of that agency from 2010 to 2015 and assisted with the troubleshooting of Secretary Clinton's private server when in that role. During Tasha Tian's deposition, another witness we deposed, Ms. Tian identified Ms. Jacks as an employee who maintained the list of gatekeepers for Secretary Clinton's communications. Tian also testified to something troubling, that several employees of that agency, that Secretariat Support Agency, may have intentionally withheld information about Secretary Clinton's email arrangements. Judicial Watch seeks to depose Mr. Gittleson and Ms. Jacks because they may have relevant knowledge of Secretary Clinton's email use. State argues that any further discovery would be cumulative or irrelevant. How do you like that? Secretary of Pompeo's State Department, that's their position. The court agrees with Judicial Watch and believes that these two former employees may offer new and relevant testimony. Mr. Gittleson and Ms. Jacks may be questioned within the parameters set forth in the court's December 6, 2018 memorandum opinion and order authorizing discovery about their knowledge of Secretary Clinton's email and any other non-privileged conversations pertaining to her email use. Accordingly, the court grants Judicial Watch's request to depose Mr. Gittleson and Ms. Jacks. Paul Combetta. Mr. Combetta is an IT specialist who was involved with the transfer and deletion of Secretary Clinton's emails. Judicial Watch seeks to depose Mr. Combetta to learn more about the archiving, existence, and deletion of any of Secretary Clinton's emails. Judicial Watch asks the court to require Mr. Combetta to bring to his deposition all records in his possession relating to Secretary Clinton's emails from her time at State. On December 30th, 2019, Judicial Watch informed the court that Mr. Combetta would assert his Fifth Amendment privilege against self-incrimination if Judicial Watch served a subpoena on him. And there's a footnote. The Justice Department gave, of course, Mr. Combetta limited immunity, only limited use immunity during the FBI's investigation into Secretary Clinton's private server. The court sees no reason to authorize what would be an exercise in futility. Accordingly, the court denies Judicial Watch's request to depose Mr. Combetta. So we're not able to depose that witness whose testimony he may have lied about what he knew and what he did. In fact, there's evidence strongly suggesting he did. And the court's saying, if he's going to take the Fifth, we're not going to bother. So I want to be clear here. The Fifth Amendment's being invoked to prevent us from getting testimony in this civil case. Did you see headlines about that? I doubt it. State Department interrogatories. So these interrogatories are written questions that require responses under oath in writing. And you can serve it on witnesses or collectively on an agency in this case. And I'm reading this not because we won, it's because I want you to know what we're thinking about and what the court is ruling. Judicial Watch seeks to serve two additional interrogatories on State. First, Judicial Watch asked State to identify the number of FOIA lawsuits pending in 2014 that sought records relevant to Secretary Clinton's emails from her tenure at State Department. So we want to know what else was going on and who else might have been being lied to. Of the total number of these lawsuits, Judicial Watch asked State to identify the number of lawsuits the State Department attempted to settle from January 14th through February 2015. The court agrees with State and holds that the first request is ambiguous and therefore inherently burdensome. The information Judicial Watch seeks is likely also publicly available. The court denies the first request. The second request is similarly ambiguous, unduly burdensome, and disproportionate to the needs of the case. Additionally, the request seeks information related to internal settlement discussions, which likely would be protected by the work product doctrine, which means that attorney work product is typically not subject to disclosure and discovery absent strong reasons. The likelihood of receiving relevant non-privileged information does not warrant the search, so the court denies the second request. So we didn't get what we wanted there, but you can see what we're concerned about and what we're suspicious about. They were only lying to us and lying and messing with this court, but lying to others and messing with other courts. And I would have hoped the State Department and the Justice Department would have been forthcoming in telling us about the additional potential corruption. Instead, they fought us and won in this case. So now they get to hide their potential corruption. Subpoena for documents. Judicial Watch seeks to subpoena Google for relevant documents and records associated with Secretary Clinton's emails during her tenure at State. The subpoena seeks to discover new emails, so it certainly relates to whether State conducted an adequate search. But State points out that Judicial Watch fails to explain how this search would be any more fruitful than the FBI's extensive investigation into Secretary Clinton's missing emails. According to State, the request is disproportionate to the needs of the case because it is highly unlikely that Judicial Watch would receive any relevant information or emails that the FBI or DOJ Inspector General failed to uncover. The court is not confident that State currently possesses every Clinton email recovered by the FBI. Even years after the FBI investigation, the slow trickle of new emails is yet to be explained. For this reason, the court believes the subpoena would be worthwhile and may even uncover additionally previously undisclosed emails. Accordingly, the court grants this request. So we get to subpoena Google about Hillary Clinton's emails because it looks like the evidence is that I think it was Paul Combetta, but one of her email vendors may have emailed all of her emails to a Google email address. So that's one of the issues we'll be looking at through this subpoena. Cheryl Mills. Judicial Watch seeks to depose Cheryl Mills on all areas of discovery. Ms. Mills, appearing as a non-party in this case, opposes this request because Judicial Watch already deposed her in Judicial Watch's FOIA case before Judge Sullivan, which I already told you about. According to Ms. Mills, any further discovery would be duplicative because she already testified for 7 hours during her previous deposition to all relevant issues in this case. Judicial Watch argues that it should be able to depose Ms. Mills in this case because it knows more information now than it did when it deposed her in 2016. The court sympathizes with this argument now that Judicial Watch has had better understanding of what happened. It should have an opportunity to craft new questions derived from newly discovered facts. When Ms. Mills was deposed, Judicial Watch was not aware of the 30,000 deleted Clinton emails or that a congressional subpoena had already been served on Secretary Clinton for her Benghazi records. Furthermore, State's mishandling of this case opened up discovery in the first place, and Judicial Watch should not be prohibited from asking Ms. Mills about what it learned from discovery just because she was deposed over 3 years ago in Judicial Watch's case before Judge Sullivan. To the extent Judicial Watch tellers relevant, non-duplicative questions, and those questions fall within the parameters set forth in the court's December 6, 2018 Memorandum of Opinion and Order authorizing discovery, the court grants Judicial Watch's request to depose her on all areas of discovery. Judicial, now Secretary Hillary Clinton. This is what you've been waiting for, right? Judicial Watch believes it is necessary to depose Secretary Clinton because significant questions pertaining to her state of mind remain that only she can answer. Secretary Clinton, appearing as an intervener in this case, disagrees. So Mrs. Clinton is involved in this case directly. She argues that the only relevant information she would have knowledge of is whether she used a private server to evade FOIA. State's settlement attempts and its search for records in response to Judicial Watch's FOIA request occurred well after Secretary Clinton's departure. The court mostly agrees with Secretary Clinton here. Any further discovery should focus on whether she used a private server to evade FOIA, and as a corollary to that, what she understood about states' records management obligations. The sole exception to these limitations, the court writes in a footnote, pertains to the records of the Benghazi attack, which will be explored further in the next section of this order. But Secretary Clinton maintains that she has already testified extensively and in multiple settings about her reasons for using a private server, so any additional discovery would be duplicative. She reminds the court that the findings of this Benghazi Select Committee, the State Department Inspector General, and the FBI all relate to her use of a private server, and they all are publicly available. Additionally, Secretary Clinton answered several questions related to her reasons for using a private server through interrogatories in Judicial Watch's case before Judge Sullivan. Secretary Clinton specifically highlights the interrogatories that focus on how, when, and why she set up and used a private server. Furthermore, because Secretary Clinton was a high-ranking government official, she argues that the Apex Doctrine requires Judicial Watch to demonstrate that extraordinary circumstances justify this discovery request. According to Secretary Clinton, Judicial Watch cannot meet that burden because her existing publicly available testimony already answers Judicial Watch's questions. For its part, Judicial Watch argues that Secretary Clinton's existing testimony has only scratched the surface of the inquiry into her motives for setting up and using a private server. Secretary Clinton has repeatedly stated that convenience was the main reason for using a private server, but Judicial Watch justifiably seeks to explore that explanation further. Judicial Watch also requests permission to question Secretary Clinton in greater detail about her understanding of states' records management obligations, including questions about her various trainings and briefings regarding these obligations. Judicial Watch correctly points out that many questions regarding her understanding of these obligations still remain unanswered. For example, how did she arrive at her belief that her private emails would be preserved by normal State Department processes for email retention? Who told her that? If anyone, and when? Did she realize that state was giving no records responses to FOIA requests for her emails? If so, did she suspect that she had any obligation to disclose the existence of her private server to those at the state handling the FOIA requests? When did she first learn that state's records management employees were unaware of the existence of her private server? And why did she think that using a private server to conduct State Department business was permissible under the law in the first place? Again, who told her that, if anyone, and when? These areas of inquiry have not been explored in nearly enough detail to convince the court that Secretary Clinton does not have any new testimony to offer. The court also needs to know, again, the court needs to know whether Secretary Clinton was aware of the active steps taken to prevent others at state, especially those who worked in records management, from learning about her private server. In a December 24, 2010 email exchange, one State Department official accidentally sent an email which listed Secretary Clinton's private email address to other employees who did not already have that information, prompting a second State Department official to reply, quote, "Be careful, you just gave the Secretary's personal email address to a bunch of folks." The first official responded, "Should I say don't forward? Did you notice?" The second official replied, "Yeah, I just know that she guards it pretty closely." How could Secretary Clinton possibly believe that everyone at state knew about her private server if her subordinates took pains to ensure that her email address would not be widely disseminated? Was she aware of this attempt or any other attempts to keep other State Department employees in the dark? Secretary Clinton's answers to these questions directly relate to her understanding of her records management obligations. As extensive as the existing record is, it does not sufficiently explain Secretary Clinton's state of mind when she decided it would be an acceptable practice to set up and use a private server to conduct State Department business. Even Huma Abedin, one of Secretary Clinton's closest confidants, testified that Judicial Watch would have to ask Secretary Clinton herself to ascertain whether the Secretary knew if her use of a private server satisfied her FOIA obligations. That came from our testimony. We deposed her. The court authorizes Judicial Watch to do so. And contrary to Secretary Clinton's assertion, the Apex Doctrine does not shield her from testifying. And he drops a footnote about the Apex Doctrine, which is interesting. It is true that high-ranking officials should not, absent extraordinary circumstances, be called to testify regarding their reasons for taking official actions. But the only person who can speak to Secretary Clinton's reasons for setting up and using a private server and her understanding of states' records management obligations is Secretary Clinton herself. Secretary Clinton unquestionably has unique first-hand knowledge of these matters, so Judicial Watch has demonstrated, quote, extraordinary circumstances, unquote. So back to the main text. It's interesting, isn't it? And it shows you the hard work that Judicial Watch has to engage in to get justice. Because Judicial Watch has convinced the court of the need for further discovery from Secretary Clinton, the only remaining issue is whether the court should authorize additional interrogatories or a deposition of Secretary Clinton. As the parties point out, Secretary Clinton already answered interrogatories in Judicial Watch's case before Judge Sullivan. But after carefully considering the discovery materials uncovered in this case and Judge Sullivan's case, including Secretary Clinton's responses, the court believes those responses were either incomplete, unhelpful, or cursory at best. Simply put, her responses left many more questions than answers. The court expects that additional interrogatories will only muddle any understanding of Secretary Clinton's state of mind and fail to capture the full picture, thus delaying the final disposition of this case even further. The court has considered the numerous times in which Secretary Clinton said she could not recall or remember certain details in her prior interrogatory answers. In a deposition, it is more likely that plaintiff's counsel, we're the Judicial Watch and we're the plaintiff, could use documents and other testimony to attempt to refresh her recollection, and so to avoid the unsatisfying and inefficient outcome of multiple rounds of fruitless interrogatories and move this almost 6-year-old case closer to its conclusion, Judicial Watch will be permitted to clarify and further explore Secretary Clinton's answers in person and immediately after she gives them. The court agrees with Judicial Watch. It is time to hear directly from Secretary Clinton. Accordingly, the court grants Judicial Watch's request to depose Secretary Clinton on matters concerning her reasons for using a private server and her understanding of states' records management obligations, but denies its request to depose her on all other matters with one exception outlined in the next section of this order. So we wanted to question her broadly on many issues, as you might imagine, and the court said, no, I have some information I want and need, and you can question her on that. Next section, Benghazi attack records. Finally, Judicial Watch seeks to question both Secretary Clinton and Ms. Mills about the preparation of talking points for former UN Ambassador Susan Rice's September 6, 2012 media appearance, the advanced dissemination or discussion of these talking points, the aftermath of Rice's appearance, and the department's evolving understanding of the Benghazi attack. Judicial Watch argues that their answers will provide more information regarding the adequacy of states' search. Secretary Clinton specifically opposes this request. She argues that questioning her about the government's response to the Benghazi attack has no relevance to the underlying FOIA and falls outside the parameters set forth in the court's December 6, 2018 memorandum opinion and order authorizing discovery. Additionally, she highlights the request as proof that Judicial Watch might seek to improperly expand the parameters of discovery if the court permits Judicial Watch to depose her. The court holds that Secretary Clinton and Ms. Mills cannot be questioned about the underlying actions taken after the Benghazi attack, but they may be questions about their knowledge of the existence of any emails, documents, or text messages related to the Benghazi attack. Such inquiries would go to the accuracy of the search without expanding the parameters of discovery to include the substance of the government's response to the attack. Accordingly, the court grants in part and denies in part this request. The parties shall complete this round of discovery within 75 days unless they seek additional time. The court will hold a post-discovery hearing to set a further schedule herein. It is so ordered. Dated March 2nd, 2020, signed by Royce Lamberth, United States District Court Judge. How you like them apples? Hard-fought litigation by Judicial Watch, battling Hillary Clinton in court about the discovery, about whether she'd be questioned at all, about what she would be questioned on, and we came away with one of the most significant victories in this whole scandal. The direct questioning by a private party, Judicial Watch, on behalf of you, the American people, in the public interest of Hillary Clinton about her email practices, what she knew, when she knew it, in terms of her record management and her obligations under law. This type of questioning has never been conducted. We would have liked to ask more, but we can't. We understand that. We're not going to win everything here. We wish we had. But I want to thank you for your support through the years that has brought us forward to this point. We wouldn't be able to do it. We wouldn't be able to stay in court for years to try to get access to this information. You know, everyone, and this is what I hate about this town, and this is why I love Judicial Watch, because the corrupt people that run this city, that run Washington, D.C., whenever you catch them in misconduct, they understand there's like there's a half-life to it in terms of public interest, and they hope that after that public interest wanes, or so they think, that they should be able to move on and be immune from any accountability under law in any way. You know, Judge Lamberth, in initially opening discovery, I get you the quote here. He called it the Clinton email system was one of the gravest modern offenses to government transparency. Now, the Justice Department, rather than prosecuting anyone about this scandal, covered it up and is still trying to cover it up. But Judicial Watch, we're here on behalf of you, the American people, holding Hillary Clinton accountable under the rule of law. And I don't know what her plans are for public life. Is she going to run for president or vice president? I don't know. It doesn't matter, though. We began pursuing this information long before she was running for president, and we will continue, as you can see, whether or not she's in public office or not. Just because you lose, it doesn't make you immune from court scrutiny or accountability for wrongdoing and misconduct. So we're going to take this seriously. Our lawyers will prepare the deposition. We'll schedule it with Mrs. Clinton, assuming she doesn't object or try to appeal it in some way. I doubt that will happen, but we'll see. So tell us, what are the types of questions folks normally have about this or are having about this in light? When is it going to happen? We don't know. You know, typically in a case, in civil discovery, you know, I use civil in the traditional sense of the word, polite. You kind of try to figure out a mutually agreeable date, and you have the deposition. Where is it going to take place? I don't know. And I probably wouldn't tell you if I did. And I wouldn't be proper to tell you because we don't want a bunch of people messing with our court process here. Will it be videotaped? I don't know. Our other depositions have been videotaped. Will the videotape be public? I don't know. The other videotapes of the depositions are under seal, so I suspect that will be the case here, absent a change of heart by the court. Well, is she going to just say, I can't remember, I don't recall, I don't remember, I don't recall, and what good is that? Well, I don't think she'll necessarily do that. And look, you can go into depositions, and there are many answers that you can honorably give and honestly give, where you say, I don't remember. But it will be up to the judge, and the deposition typically will be made public, at least in writing, and you, the American people, you can look through the material, and the judge certainly will, and
make a credibility determination as to whether any failures to recall are credible. And so she can say that, and that will be taken and judged by court as to whether that's credible. But in the least, she'll have to go on the record about the issues the court has laid out here. Can she take the Fifth Amendment, or will she take the Fifth Amendment? Highly unlikely. Because as I suspect, the Justice Department has zero interest in pursuing justice against Hillary Clinton. I don't know why, but that's the case. So those are the big questions out there, and we will keep you apprised of this discovery process. As you can see, it's not just about Hillary Clinton. Cheryl Mills is a key figure here. The court previously, in discussing Ms. Mills, said he was aghast that the Justice Department gave her immunity because in another Judicial Watch case regarding Clinton emails from the Clinton White House and Hillary Clinton, the court found that she had committed perjury. And she said, he said, why does the Justice Department give this person immunity again? Immunity for her activity here. So that's going to be important testimony. And as I told you, those two State Department witnesses, they were at the center, they were kind of at the intersection of the State Department bureaucracy in terms of managing her email system. So that will be important. And who knows what we'll find with this Google subpoena. So 4 testimonies, 1 big subpoena. And I'll give you the information as it becomes available and as the testimony is taken and I'm able to make it public. So this is just big news, obviously. And I tell you, it shows you the value of Judicial Watch, doesn't it? Congress isn't going to do anything on this. The Justice Department and the State Department are actually opposing us on this. They don't even want to look for her emails in the State Department. Did you hear that part of the judge's ruling? Did you catch that? They don't want to search the State Department for her emails. That's how bad it is over there. So it's Judicial Watch to the rescue again for the rule of law and accountability. But in the end, we want the documents. We have a right to see the documents here. And the law needs to be vindicated. If FOIA is to mean anything, if there's to be any transparency law, you can't allow the head of an agency to do all of her business, in this case, on a separate email system. And the only reason we caught it was because of our FOIA case. That shouldn't be the case. It's one way you might as well not have FOIA if you can get away with that. So we're really trying to protect accountable government through these types of cases. So like I said, 75 days, May 16th. It's going to happen over the next few months. And so stay tuned. And again, thank you for your support. It's been years and years of seeking justice here. It's not perfect justice, but it's a significant development further towards full justice and accountability, at least with respect to the Clinton email scandal, which is ongoing, as the court notes. They're still giving us emails. Incredible stuff. So speaking of justice and accountability, we need some over on the Hill here, don't you think? Did you see that video of Senator Schumer threatening witnesses? You were a witness to a crime, it looks like. Senator Schumer was, there was a big hearing, Supreme Court oral argument this week on really a modest abortion law related issue. Louisiana set up a law that requires doctors who commit abortions to have admitting privileges in a hospital. Common sense public health safety law. And so rather than women, quote, challenging this, you had the abortion industry challenging this, which was the basis for our amicus briefs with the court. But the left is crazed about abortion. I mean, they not only want abortion to be legal throughout the 9 months of pregnancy, now they're defending politicians who talk about allowing babies to be killed after the 9th, after they're born. So, in this case, it doesn't prevent any abortions at all. It just actually increases the safety of women seeking abortions.
So, but ideology is key here. So that's common sense, science, and biology takes a back seat. So abortion is a major animating issue for the left. In many ways, so many of our public policy fights in Washington are often about issues, are not about the issues that they presumably are about given the nature of the fight. For instance, the issue of impeaching President Trump, it wasn't about anything Trump did wrong. It was about a whole host of other issues behind it, including taking him out and making it difficult for him to appoint Supreme Court justices because they're nervous about the abortion right, which currently allows women to kill babies, unborn human beings, throughout the entire 9 months of pregnancy if they can get a doctor to do it. That's the law. You didn't vote on it. The Supreme Court mandated it. And they're obsessed with making sure that never changes, either through a judicial removal of that law or by, in the meantime, allowing states to modestly increase the protections for unborn human beings. So the left had a giant rally outside the Supreme Court, which I don't know what the purpose of it is, because is the Supreme Court supposed to decide based on the law or what people are screaming outside its portal? But Schumer said, or actually screamed, "I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind and will pay the price. You won't know what hit you if you go forward with these awful decisions." Can you believe that? Threatening 2 Supreme Court justices? You will pay the price. You won't know what hit you. You will pay the price. You won't know what hit you. If I had said that, I'd have 2 U.S. Marshals in my office, or frankly, probably in my home, in the least questioning me, questioning my family, questioning everyone here at Judicial Watch, anyone else I had talked to, about that threat on the Supreme Court. Justice Roberts responded, rightly so, said that type of language is dangerous. Dangerous. Of course it is. And the left has suggested Trump has said something similar. He's never said anything similar. You can criticize, you could change this language around quite easily to make it acceptable. You will pay the price in history. The American people will criticize you for not protecting their abortion rights. All sorts of things you could say. That is a fair exercise of your First Amendment rights. But you don't have the right to threaten another person with violence. And you being a senator is no excuse. And you're not exempt from the law. At least you ought not to be. What are the laws at issue here? Landmark Legal Foundation, our friends over there, they filed a quick ethics complaint against Schumer on this. They cited the laws. 18 U.S.C. Section 875C, interstate communication containing a threat of injury. 18 U.S.C. Section 1503A, threats of force in an effort to intimidate an officer of the court. In the least, you could have a conspiracy claim. All sorts of criminal complaints could be filed against you here. If I were Gorsuch, if I were Kavanaugh, I'd walk over to the Washington field office of the FBI and I'd file a criminal complaint against Schumer. What's going to happen in the Senate? I bet you nothing. There are 15 senators maybe that want to censure him. But unless they hear from you, the Senate, they won't do jack. Am I allowed to say jack? Is that a bad word? I don't know. My colleagues are laughing at me because I never say bad words on TV. I don't think I do. But isn't that outrageous? I tell you, You know, this coup was never just about Trump. They're trying to destroy every single one of our institutions. The left hates our Constitution. They hate any restrictions on their ability to obtain and retain power, and they will pretty much say or do anything. The Constitution, the rule of law, crime, criminal laws, all of that, they don't care. Schumer's spokesman immediately starts lying about what he said. Oh, he wasn't threatening the judges. He was talking about a political price to senators. I read this to you. We're not taking anything out of context here. Schumer gets on the floor of the Senate because there's all this criticism. He doesn't really apologize and says, I would never make a threat. Well, he just did make a threat. What do you think ought to be done? Well, you should call your senator. He should be expelled. That's what I would do if I were senator. Why is this man in the Senate after threatening violence on Supreme Court justices, encouraging violence on Supreme Court justices to get a result in a case that he has an interest in? I mean, they're talking about censuring him. That's the least they can be doing. Where's the Justice Department? Where is the U.S. Marshal Service? Marshals protect the courts, protect the justices. You go into a federal courthouse, security is extreme. These courts are under constant threat. They're putting bad guys away in a direct way, confronting these bad guys in person. Security is paramount. Call your senators. Let them know what you think about what Senator Schumer said. Because if you don't, you're not really in a position to complain about any inaction that follows. Call them at 202-225-3121. That's 202-225-3121. If you're not sure who your senator is, and I'm not one of these arrogant leftists who will criticize you for not knowing who your senators are, because a lot of your senators are basically non-entities, practically speaking. So it's not surprising if you don't know who they are to me. But look them up, call them. You can call them directly if you go online these days. I don't need to tell you how to find someone out online. Call them up and let them know what you think. And I don't know what the Justice Department's doing, but they need to be investigating Senator Schumer over this. And if I were the president, I would direct the Justice Department, I would direct the U.S. Marshals to criminally investigate what Schumer said and come back to me as president with recommendations as to whether to prosecute him or not. And then as president, if I were President Trump, I would say, I will make the final decision as to whether this man is prosecuted. I'm the president of the United States. The Constitution puts that power on me. And I'm going to make this decision. It's that important. That's what I would do. So I encourage the president to do that too. Give the White House a call, 202-456-1414, 202-456-1414. There's got to be some justice here. There's an ethics complaint by the Landmark Legal Foundation, which is great. But the ethics process in the Senate's broken. We had... Who do we have? Who's the Spartacus senator? Who was Spartacus? Oh, Senator Booker. He admitted he violated Senate rules in trying to destroy Kavanaugh. He admitted to violating the rules in releasing confidential documents improperly. We filed an ethics complaint. They didn't want to pursue it. In the Kavanaugh confirmation, the Justice Department had material referred to them for prosecution over the lies and smears and conspiracies against Kavanaugh that were illegal. What's the Justice Department done on that? Nothing. This is why the president has got to start exercising his prerogatives as president to enforce the rule of law. He can't rely on the Justice Department to do it. And it doesn't mean that Barr is a bad guy or he doesn't want to do anything. It's just institutionally, It's just been, it's so far fallen, they can't do the basics. As I said, the coup goes after Trump. They go after the president. You had the House abused by Schiff and Pelosi. They threatened the Senate. Now we've got senators from the left threatening the Supreme Court. And we're all supposed to just move on, right? Schumer is it was a 2-day story and we're supposed to move on from the criminality. Judicial Watch isn't going to move on, and I hope that you don't move on. And I hope you let your members of Congress know you don't want them to move on. I mean, we had the president impeached on a fraud. When did it happen? It's like a month out. No one talks about it. Joe Biden is, of course, the key element of that was to protect Joe Biden. As I said, there's always a million reasons, not the one they're saying they're impeaching him on. There's always a million reasons. There's always something else behind what you see publicly stated in D.C. policy or controversies. It was protect Biden. So it's a month later, Biden is on a track to become the nominee for the Democratic Party for president. It's not guaranteed. He still has a big fight with Sanders. Where's the corruption investigation of Biden? Effectively frozen. Effectively frozen. Judicial Watch has lawsuits that we're pursuing. We didn't give up. We're not moving on. And we're not going to move on from Schumer. We're not going to move on from Schiff. We haven't moved on from Hillary Clinton. We even haven't moved on from Benghazi, dare I say it. Am I allowed to talk about 4 Americans murdered and their cover-up of that death and the cover-up of those deaths to help Barack Obama get back in office? We're not going to move on from Spygate. Our country's at stake. Our republic is tottering, as I've been saying. So forgive me for getting a little heated here. These are grave attacks on our constitutional republic. And you can see through the court process that there are ways to get it back under control. That's the reassuring thing. It doesn't take that much to get things back under control, but we just have to do the basics. So enough about that. Let's move on to another big case. And so the left, we think the left is so active all over the place. There are all these assaults on the rule of law in all areas of our lives from the left, pushing their agenda. And California is kind of a prime example of that because you have the far left controlling the state politically there. So they pass pretty much every idea they have. And whether the law would allow such policies to be enacted, they don't care. It's, let's do everything we can and we'll see what gets caught up in the law. If it does, it does. If not, who cares? We got it. They tried to, for instance, to mandate the release of tax returns for presidential candidates to get on the ballot, adding an additional qualification to the Constitution's qualifications clause. And Judicial Watch sued and stopped it, along with the president. He filed separately, but we were in court together, practically speaking, and we both won. So we beat them back on that. But they also they also passed a law that they knew was unconstitutional, even under state law specifically, requiring a quota for females on the board of directors of corporations. Unbelievable. Before the bill passed, the California Assembly floor analysis identified a significant risk of legal challenges, obviously. It characterized the legislation as creating a quota-like system and noted this bill, if enacted into law, would likely be challenged on equal protection grounds. So when you tell men they need not apply for certain positions on board of directors, that's obviously a denial of equal protection under the law. The use of a quota-like system as proposed by this bill to remedy past discrimination and differences in opportunity may be difficult to defend. In signing the law in September 2018, then Governor Brown wrote that serious legal concerns have been raised to this legislation. I don't minimize the potential flaws that indeed may prove fatal to its ultimate implementation. He signed the bill anyway, noting, nevertheless, recent events in Washington, D.C. and beyond, Trump, make it crystal clear that not many are getting the message. So they were going to pass, and they signed an unconstitutional law to throw smack at Trump. So they're passing this quota law because they don't like Trump. It's crazy. So we filed a lawsuit on behalf of taxpayers because California has a taxpayer standing statute. What does that mean? It means a taxpayer standing it allows taxpayers to have standing, I should just say. The taxpayers can challenge illegal expenditures to enforce illegal laws. Meaning if there's a taxpayer money being spent to enforce or advance an illegal law, taxpayers would go to court and challenge it and stop it. So, as we say, the legislation's quota system for female representation on corporate boards employs express gender classifications. It's immediately suspect and presumptively invalid and triggers strict scrutiny review. Strict scrutiny is a legal way of saying you really need good reasons to get by here. We're going to look at it closely. And of course, you know, the policies really don't help women. As we note in there's a Boston Globe piece that said, too often such policies are disingenuous forms of virtue signaling that benefits only the most privileged and does little to help average people. Requiring companies to make gender the primary qualification for board membership will inevitably lead to less qualified private sector boards, exactly what happened when Norway adopted a nationwide corporate gender quota. Norway's gender quota led to younger and less experienced boards and deterioration in operating performance consistent with less capable boards. Someone else noted that increasing the number of opportunities for board membership without increasing the pool of qualified women to serve on such boards has led to a golden skirt phenomenon, where the same elite women scoop up multiple seats on a variety of boards. So someone like Susan Rice, Hillary Clinton, Condi Rice, notable women that you've heard of, they benefit from these types of quotas, but few others do. And it harms businesses. So they're in pursuit of this unconstitutional ideological agenda. They would harm businesses that you invest in, either directly or through retirement and other pension funds. And California has essentially admitted we're right. You know why? Because they said we're not enforcing the law. Well, actually, they kind of are, but they're trying to draw a distinction with the court. So they're running away from their own law in part because they know we're right. So what is the court going to do? We don't know. We have a hearing next week on it. So we filed this lawsuit in August. We have the hearing, which should give us a strong signal, typically, as to whether this law is going to be thrown out. Don't you love Judicial Watch doing this work for you? And we need to be bigger. We need more support to do more of this work. And if you're not supporting our work, Hillary Clinton, on the deep state coup here in Washington, protecting our rule of law in our country from the illegal immigration crisis, the election integrity work that we do that is essential in terms of cleaning up rolls, advocating and defending
voter ID and other sensible, clean election measures, exposing everything the government's doing, we do it with your support. And I hope you'll continue to support us if you already are, with additional support. And if you're not on our email list or mailing list, I want you to join us. No one else is doing the work that Judicial Watch is doing. And we're only able to do it with your support. So thank you, and I will see you next week with another Judicial Watch Weekly Update.